All right, will prosecutors seek the death penalty in the Justin Ross Harris case? Harris is accused of murdering his son by intentionally leaving him locked inside a hot car. We reached out to the DA, who told us they are still considering the death penalty, but have not yet made a decision on all of that. So, who has been sentenced to death by jurors in Cobb County? Well, these right here are the 7 men who have been convicted by Cobb County juries, and they're currently serving life on death row, waiting to be executed. Now, none of these men murdered their own sons. Instead, they were convicted of things like rape and robbery, murdering the family members of co-workers, and a police officer as well. So, I took a look at the Department of Corrections to see if there are any fathers on death row who murdered their own children. I found one, just one. That's him. His name is William David Riley. He set his own home on fire. His 3 children were sleeping inside. The children's ages 3, 5, and 6. So here's the question. What makes a murderer eligible for the death penalty in Georgia? Well, let's take a look at the law. First, the element of malice or express malice, where circumstances of the killing show an abandoned and malignant heart. Second, the state has to prove at least one aggravating circumstance. One example of that is outrageously or wantonly vile, horrible, or inhuman, in that it involved torture, depravity of mind, or an aggravated battery. So, should the death of little Cooper be a death penalty case? Joining me to debate all of this today, 2 great attorneys, Ashley Merchant, death penalty qualified attorney from Marietta, and Phil Holloway, who is a former cop, former prosecutor, now a great defense attorney as well. So let me start with you, Ashley. Why, because I know your opinion about this, why isn't this the case of Justin Ross Harris, a death penalty case?
Well, first of all, Cobb County juries don't have a problem imposing the death penalty, but the question is whether or not the prosecutor is actually going to seek it.
Right.
I don't think that this is a death penalty case.
Why?
Because Harris didn't actually kill his child. He didn't. I think they're going to have a hard time showing that he intentionally killed his child. I think this is more of a negligence case, and I think that normally they seek the death penalty when someone actually put their hands on their child or on the person and actually killed them with their own hands. It's very hard to prove a death case or get the death penalty when you've got someone who didn't actually watch the person die. So I think that that differentiates it.
All right. What would you have to hear? What type of evidence do you think would make this a death penalty case? Because we've heard some of the evidence already.
Well, we've heard a summary of what the police say the evidence is. We don't actually know what the evidence is. I certainly haven't seen it. I don't know what it is. But what I can tell you is if they can prove beyond a reasonable doubt that this father intentionally planned, with premeditation and deliberation, and with that abandoned and malignant heart that you mentioned, Vinny, if they can prove to the satisfaction of a jury that that is the circumstances surrounding this child's death, then he may very well be qualified for the death penalty.
All right, Ash, let me throw this out on the table here. If it was a teacher or a babysitter who took Cooper and placed him and locked him inside that car knowing he was going to die, I think people would be saying, it's clear that would be a death penalty case. Right. Do you think we're giving this guy a break because he's the child's father?
I think we have a hard time thinking that a father would kill their own child. I think that we are giving him a little bit of a benefit of the doubt, thinking that it's more likely that it was a mistake, that he is not actually intending to kill his child. So I think that we are giving him a little bit of a break. And I'd also like to point out one of those gentlemen that you put up there from Cobb County, Lawrence Rice, he's actually my former client, and he actually did kill a child. It wasn't his own child, but he was actually convicted of killing a child. So there is a history in Cobb County. Cobb County jurors do not like deaths of children. It's a very easy case for them to impose the death penalty.
All right, Phil, you're like my insider in this case, right? You practice in that courtroom all the time, in that courthouse. Will the DA seek the death penalty? He hasn't let us know. We called him again and again. They haven't come to a decision yet. What do you think is going to be the decision?
We may know as early as this Thursday. As of now, he's scheduled for an arraignment this Thursday afternoon, and under Georgia law, the DA has to make that announcement at or before the first appearance, which would be, unless it gets rescheduled, this Thursday. So we should know perhaps very, very soon. Prosecutors take into consideration something known as residual doubt, however, when they make the determination about whether or not to seek the death penalty, Vinny. They could very well be confident that they can prove malice murder. They may also, speculating here, they may have doubt whether or not they can get a jury to impose death under these circumstances, because it's counterintuitive. Why would a father intentionally, in a knowing and planned way, kill their own child?
Yeah, again, it comes back to, it's like he's getting a break for being the child's father, which I think would be an aggravating factor in all this. But great job. We're going to have you guys back as often as you'll come back in our coverage of this case. Thanks so much.
Happy to. Thanks.
You.
All right, it's 6:43.